All right, welcome back to House Education, May 4th. Now going to have a walkthrough and discussion on S-138, the school safety bill, with the potential that we will vote it out of here. Much Council is going to walk us through, and we'll discuss and proceed as we can. Welcome back.
Hello. St. James Office of Legislative Counsel, you all should have posted on your website draft 4.1, which I know is silly because this is the first time we're walking through it. It is a committee amendment to S-138, which is the school safety bill. And it's an instance of amendment. So it's not striking the whole bill. It's keeping most of what the Senate passed, and then you are making discrete changes. So the first instance of amendment, do you all have it up? Okay, great. The first instance I just added based on a comment by the chair yesterday. I don't know if this language is what you were intending to get at, but it's a amendment to the first section of the bill, which requires option-based response drills. And there's a comment or discussion yesterday about requiring parental notification before a drill takes place. So I added this language, but I'm happy to take direction and wordsmith it to your liking. It reads, so you're not striking any language, you're just adding that the policy has to require notification to parents and guardians not later than one school day before an option-based response drill is conducted. Does that get at what you all were trying to do?
Yes.
Okay, great. So the second instance of amendment is actually a strike to the entire section 4 as passed by.
100%. We were also going to, I think, add age appropriate in there. I'm not.
There you go, that's great.
Before the response drill. I had a nice little packet of language changes I don't have anymore. I don't have the full bill in front of me.
Let's see. So we're still in section 1. We're talking still about section 1, right? The
Yes.
options-based response drills.
Yeah.
And you want to add something about, is it the drill that would be age appropriate? Okay. Add that language. Okay. Section 4. I'm sorry. The second instance of amendment is actually a strike of the entire section 4 that the Senate passed. This is behavioral threat assessment teams language that we all talked about yesterday. So I'm just going to walk you through it, and then stop me at any time you have questions. So we're going to, again, add a new section to that chapter we talked about yesterday in Title 16, 1485, and the name of the section will be Behavioral Threat Assessment Teams, and it starts with a piece of legislative intent. It is the intent of the General Assembly that behavioral threat assessment teams be used for the purpose of preventing instances of severe and significant targeted violence against schools and school communities, such as threats related to weapons and mass casualties and bomb threats. The goal of these teams is to assess and appropriately respond to potential reported threats to school communities. Subdivision 2, I'm on page 2. It is the intent of the General Assembly that use of behavioral threat assessment teams shall not contribute to increased school exclusion or unnecessary referrals to students to the criminal justice system and school discipline. Oh, okay. Sorry, I was not reading it well. Unnecessary referrals of students to the criminal justice and school discipline systems and shall not disproportionately impact students from historically marginalized backgrounds, including students with disabilities. Any questions before we go to policy? So we start on line 7 here with a definition is used in the section. Behavioral threat assessment means a fact-based systematic process designed to identify, gather information about, assess, and manage dangerous or violent situations. It requires the Secretary of Education, in consultation with stakeholder groups, including the Vermont School Boards Association and Vermont Legal Aid Disability Law Project, to develop and from time to time update a model behavioral threat assessment team policy and procedures. In developing the model policy and procedures, the Secretary shall follow guidance issued by the Vermont School Safety Center on best practices in the use of behavioral threat assessment teams. The model policy and procedure shall require law enforcement contact in the case of imminent danger to individuals or the school community and shall address the following. The criteria that shall be used to assess a student's threatening behavior, the process for reporting threatening behavior. I'm on page 3 now. The civil rights and due process protections to which students are entitled in school settings. When and how to refer to or involve law enforcement in the limited instances when such referral is appropriate, which shall not include student behavior that is a violation of the school conduct code, but that is not also a crime, and the support resources that shall be made available, including mental health first aid, counseling, and safety plans.
Oh, yeah.
Okay.
Is it up in that list that you were talking about?
Yes.
Go ahead.
So it's number 2, the Secretary of Education. I would like to add some other advocates to the stakeholder groups.
Okay, you make your case to the committee.
To the committee. Okay, so, and I think I've said this before, in every school it's required that there is a child protection team, which is embedded in every school. And when I look at the task force, the safety task force, it's basically a lot of the same members that's on the child protection team group, which is the administrator, teachers, nurse, school counselor. They bring in experts from, and it's under the kind of umbrella of Department of Children and Families. So we're all mandated reporters in school. As soon as, let's say, there's any threat in school, if someone calls a child protection team meeting, if a teacher gets writing from a kid that they're thinking of shooting someone, or if someone draws pictures of shooting someone, or a kid comes and says, so-and-so told me they're going to bring a gun to school or whatever, there's an immediate child protection team meeting where all these people meet together. The vice principal, at least this is the way it was done in my school, the vice principal goes immediately to the classroom where the kid is, takes the kid, puts them in some kind of secluded space and stays with them, searches their locker, searches their backpack, and then holds a team, meets with parents, meets with First Call, which is our designated agency, which is from Howard Mental Health, gets an evaluation from probably John Donnelly, who assesses risk assessment in kids. And that, to me, is a role of the child protection team meeting. And so my concern with this is that there are going to be 2 teams with somewhat different missions, but not that spread out. And my concern is the coordination and communication and collaboration between these 2 groups, because everybody in a school is a designated reporter. So you have to report if you're concerned about the safety of a kid, even if the team doesn't agree with you. And then DCF is the one that does the investigation.
Are you saying that in number 2?
Yeah.
On page 2?
Yeah.
You'd just like to add DCF to that?
Yes.
Who the secretary consults with?
Yes.
Okay.
Yeah.
And that wouldn't be wrapped up in the stakeholder group?
Oh, it's not there now. Pardon? It's not in there now.
No, but it says in consultation with stakeholder groups. Would they not be a stakeholder group?
Well,
It wouldn't necessarily be required unless we name it.
Okay,
Yeah.
gotcha.
Yeah.
So this is,
right. And so the goal would be just to coordinate it, just to be very clear. And maybe when you got to policies and protocols, that people would be very clear, when is a school safety team dealing with a student, who, how.
I mean, I don't think we're having language in here that's going to dictate
Right,
that.
okay.
But because all we're saying, all your proposal is saying is that in consultation with stakeholder groups, including Vermont School Board Association, Vermont Legal Aid Disability Project, and and DCF.
And I'd like to add a superintendent, a principal, and a teacher, but I probably won't get that.
Yeah.
So,
Yeah. Does anybody have any thoughts? I see no reason not to, it's just consultation as they go to develop the plan.
Sorry, add DCF.
Yeah, I don't know if we add DCF or we add AHS, but but I think, I mean, DCF is the more zeroed in on department.
yeah.
Yeah.
And they oversee the child protection team.
Yes, so what would you like me to add?
DCF.
I don't get to make the decision.
Yes. I didn't.
Thank you.
You just name the agency or name the department.
I think you can be specific to departments like
Great.
that.
Thank you, Sarita.
Thank you. Thank you, committee.
So we are on page 3, line 9. Each school district and each approved or recognized independent school shall develop, adopt, and ensure implementation of a policy and procedures for use of behavioral threat assessment schemes that is consistent with and at least as comprehensive as the model policy and procedures developed by the secretary. Any school board or independent school that fails to adopt such a policy or procedure shall be presumed to have adopted the most current model policy and procedures published by the secretary. The Vermont School Safety Center shall issue guidance on the best practices of behavioral threat assessment teams. The guidance shall include best practices on bias and how to reduce incidents of bias developed in consultation with the Office of Racial Equity. So that's the model policy piece. The next subsection is discipline and support. We're going to go on to page 4. Consistent with the legislative intent in subsection A of this section, if a behavioral threat assessment team recommends, in addition to providing support resources, any action that could result in removal of a student from the student's school environment pending or after a behavioral threat assessment, the recommendation shall only be carried out in a manner consistent with existing law, regulation, and associated procedures on student discipline pursuant to section 1162 of this title and the pupils rule, the state board rule, that's the official title of that rule. That's where the discipline pieces are, rules are, as well as federal and state law regarding students with disabilities or students who require additional support. So if the behavioral threat assessment team has a recommendation that includes removing a student from the school environment, they have to follow all of the laws that are already in place around student removal. Number 2, subdivision 2 on line 10, behavioral threat assessment shall be structured and used in a way that is intended to minimize interaction with the criminal justice system. Law enforcement and referral and involvement may be appropriate only in cases involving threats, which shall not include student behavior that is a violation of the school conduct code, but that is not also a crime. Move on to the training section. Subsection D, subdivision 1. Each supervisory union, supervisory district, and approved or recognized independent school shall ensure behavioral threat assessment team members receive training at least annually and best practices of conducting behavioral threat assessments as well as bias training. The annual training shall include the following topics. Page 5, the rules governing exclusionary discipline, which is that pupils state board rule. The purpose, use, and proper implementation of the manifestation determination review process. Section 504 of the Rehabilitation Act of 1973, the Americans with Disabilities Act of 1990, and other civil rights laws. The negative consequences of exclusion from school. The impact of trauma on brain development, and group bias training specifically focused on bias and carrying out the duties of a behavioral threat assessment team. AOE, in consultation with the Department of Public Safety, shall develop guidance and resources to assist supervisory unions, supervisory districts, and independent schools in providing the annual training required under the subsection and developing the guidance on bias training for behavioral threat assessment teams. The agency and department shall consult with the Vermont Office of Racial Equity. There's a data and reporting requirement. So does this
it requires the training, AOE and public safety are developing guidance and resources. It doesn't ultimately say who has to deliver or pay for the training.
The supervisory union, the language says the supervisory union shall ensure that the training happens, but it's not more specific than that.
Libby?
I did like, the reason I ask is like, okay, there's another requirement. Not kind of cemetery.
It's, yeah, something handy too.
That's well intended, good requirement. So I just want to see that, and it may be something small, this might be like an hour training, I don't know, but keeping in mind the totality of our work, I think about, okay, do this, but.
And we're still losing that link in there.
Like a little insight here,
Please go right ahead, Ted.
the record Ted Fisher, Vermont Institute of Education, the agency's Director of Communications and Legislative Affairs. I'm very cognizant of the concern, Madam Vice Chair. We don't have a law yet. It's early and it's premature, but one thing that we've already had some conversations about, and some conversations amongst the stakeholder group, the consensus group, is we have a training best practice model. We are also directly connected to some of the experts who developed the best practices on the use of BTA for contractual relationships and otherwise. We could very well see the training shift, not additional requirements for training. That's one thing we're going to consider is do we need more hours of training or is what they're trained on going to shift. So I can't make any promises on that, but that's certainly something that when we're cognizant of and you were talking about. We also, I just want to take a moment of personal privilege to say that I think and I'm hopeful that we might actually push the envelope in terms of best practice on this nationally, and we end up being leaders who contribute to sort of how the practices should in other states, and given the significant concerns that exist about racial equity, targeted students with disability, and some of the other things that need to come, and that's part of why we want to see these teams more regulated. We might actually, the idea that we might actually really contribute to not only proper use of them in Vermont, but elsewhere is really, is kind of exciting. And I appreciate when you say that that's just me editorializing, but we are very cognizant of the capacity concerns here, and we'll be attentive to them going forward. And certainly we'll be reporting to you on the requirements, and I apologize to you for that for taking time.
I would ditto what Ted just said, but from the committee's point of view, we will be cognizant and aware of training and how it's going.
Okay, data and collection, or data collection. We are on page 5, the very bottom, line 18, data reporting and collection, subsection E. Annually, each supervisory union, supervisory district, and approved or recognized independent school shall report data related to completion of and outcomes of all behavioral threat assessments and manifestation determination reviews to the agency in a format approved by the secretary. At a minimum, the annual report shall include the names of the members of the behavioral threat assessment team, the number of behavioral threat assessments and manifestation determination reviews conducted in the preceding year, and for each assessment or review conducted, the following information: a description of the behavior requiring an assessment, the age, grade, race, gender, disability status, and eligibility for free or reduced price school meals of the student requiring the assessment, and the results of each assessment or review. The next piece of data to be collected is the number of students subjected to more than one behavioral threat assessment or manifestation determination review, the amount of time a student is out of school pending completion of a behavioral threat assessment, information regarding whether a student subject to a behavioral threat assessment was also subject to exclusionary discipline for the same behavior, including the length of such discipline, information regarding whether law enforcement was involved in a behavioral threat assessment, information regarding whether the threatening behavior was also reported to law enforcement, and any additional data the Secretary of Education determines may be necessary.
I have a question, and I think I might direct it to Beth first, but may have to go to Ted. We've got a lot of small independent schools, that may not be worthy of a threat assessment team. There might be 16 kids or couple of dozen kids. How does that work in practice? Or how might that work in practice?
I think that's definitely a question for the field.
For the record, Ted Fisher, Finance of Education. I'm probably not the best person to answer this. I think this is, again, something that we probably want to be engaged with our subject matter experts, both at the state level and with our colleagues in the field about. We see that it's important. Again, I'm sorry, I'm cognizant of your time. I don't want to editorialize too much, but one of the things that has become really clear to us during the COVID-19 pandemic is all the way through to date is that regardless of different regulatory constructs for independent schools and not, I understand the committee has taken testimony, considered proposals in that area. Regardless of any of that, there are places where we have a duty of safety to all of our students, sort of regardless of venue. And so I think that our conversations will have to be about what these are requirements they should be followed.
Yeah, for sure.
And so we need to work that out. It may be that we have requested a reporting requirement on specifically on legislative updates to tweak things. It may be that we have to have resource conversations and guidance conversations. So I wish I could give you a better answer right now. We have a job of work to do.
Okay.
Several jobs before post passage.
No problem. Sarita.
Yeah, just wanted to ask, I'm not sure if we can go back to page 3, but just the civil rights and due process protection to which students are entitled to in school settings, that's C, and then D, when and how to refer or involve law enforcement in the limited instances when such a referral is appropriate, which shall not include student behavior that is a violation of school conduct code, but is not also a crime. That was a little confusing to me. Could you just elaborate on that paragraph and just talk, can you just kind of give me a sense of what is a student's civil rights and due process? Because I think if you're bringing police into it, it's like another jurisdiction as far as I'm concerned. And like, when can you mention a student's name to a police officer? What level of evidence or, do you need to have to tell the police officer and mention their name?
So this topic is so broad that I'm not sure I can go into that level of detail. I will say that the term civil rights and due process protections is going to depend on the situation and the issues involved. And so, I will just say that is broad language. And it depends again on the situation and the setting and the situation involved and the rights involved. The due process rights, when we talk about due process rights, in this context, generally speaking, we're talking about like notice requirements, hearing requirements, that kind of thing. And those are going to shift depending on the action that's being taken. Civil rights is a whole nother bucket, and we're talking about anti-discrimination laws and, all of the protected classes. So that's very broad language. It's not very specific.
So I assume a student is alleged, like a student is alleged to have, threatened someone or alleged. Can you share the name of a student with a police officer when they've been alleged of behavior and not substantiated?
So I think that's a really hard question to answer definitively because it really depends on the circumstances, but there's, I'm struggling because I have kind of a common sense answer that I have not spent much time thinking about. The fact that threatening behavior or a crime is occurring in a school doesn't necessarily change when a crime or a potential crime or a concern can be reported to law enforcement. There might, how information comes to someone might limit things depending on, but if there's a child waving a gun in a school, the fact that they're in a school doesn't mean you can't call the police.
Right. No, that makes sense to me. But if a teacher was sharing, let's say, a picture where a kid had shooting a teacher.
I think it would be, I'm not able to answer that question, and I think that the answer to that is going to actually comes to one of the comments I would make about this language. This language this is language that would live in the green books, right? This is proposed statute. And it's pretty specific when we're talking about subdivision D there, when and how to refer to involve. And this is what the model policy shall include. So the model policy has to include when and how to refer to or involve law enforcement in the limited instances, et cetera. I think, Representative Austin, what your questions and my inability to answer them clearly, because it's a lot of it depends on the context. These are school administrators. And so I actually have some concern over the phrase, is not also a crime. Who's determining what a crime is? I'm not so sure that that's in the school administrator's wheelhouse. So I have some concerns about what does that mean and how is that going to be used? And so I would just food for thought for the committee as you take testimony on this and you consider that. But I think it kind of gets at the conversation we're dancing around here is that it really depends.
I think you pointed out an important piece of context in this discussion, and that is this is things to be taken into account in creating a model policy.
Okay.
So as the AOE goes to create that model policy, talking with those stakeholders, a lot of this will come up as they go to develop it.
Yes, and this language is really specific that the model policy, that when the model policy declares which instances law enforcement referral is appropriate, those instances cannot include student behavior that is a violation of the school conduct code, but that is not also a crime. And so that's the, unless the model policy is going to spell out with consultation with every state's attorney in the state what behavior constitutes a crime, I just think that could potentially be really problematic, that language. The law enforcement community or your judiciary counterparts may feel differently, but sitting in the education chair, that gave me pause.
You can respond.
I'm happy to if you would like.
Sure. Yeah.
For the record, Ted Fisher, runs education. This is very carefully worded language intended to give us a very careful job of work to develop a model policy. I absolutely appreciate it, and that is an attorney and I'm not, and also did a much better job of trying what I would try to explain about this, but I'll just editorialize a little bit by saying, or maybe reframe by saying, these teams, by nature of the fact of what their intended purpose is, they will deal with incidences or potential incidences, developing incidents. Not all the information is in. We are gathering facts. They will, I'm using the word really, really carefully and really importantly, they will deal with incidents where there is a real risk of harm, where a crime has been committed, or or the exact opposite, where there is a perceived risk of harm, but a crime has not been committed. And again, even if behavior is not ultimately criminal, or if behavior is criminal, there are still due process rights associated with both of those things. If you commit a crime, you are still entitled rights. And so the goal here is to try to carefully articulate a set of safeguards to prevent behavior that may appear initially very, very concerning, but is not ultimately something where we need law enforcement involved. We've used some hypothetical thought experiments in our conversations to try to help us think about this. We do not want these teams used in instances when one student hits another student on the playground. We have examples, and yet there might be instances where one student hits another on the playground and that's assault, right? So it's something that has to be navigated, something that school administrators already navigate outside of this. It's something that by the makeup of the team and by their training, they'll be equipped to sort of help make some of those decisions. and how to appropriately consult with law enforcement in cases, sort of this. I'm very appreciative to Beth for raising that concern. We have some work to do on the policy as a result, but the reason why we put this language in, the reason why it was requested and then agreed to by all the stakeholders in this conversation is that we believe really strongly that we need the appropriate safeguards on the use of these teams so that they do not inappropriately, disproportionately target students for behavior that should not ultimately lead to interaction with law enforcement.
And I'm just going to not dive deep into the legal part, but just to say that within number 2, this model policy will be developed with the VSBA, legal aid, and now DCF.
And I'll just say that I recognize that in many places, this is, the language is somewhat awkward. But that's because we are working really carefully to thread a fine line. We believe really strongly these are necessary. We also believe that they're really strongly, they need to be properly regulated. And so you are going to be hearing from us next year. If you pass this bill, it becomes law, you're going to be hearing from us next year about the work to try to achieve the goal of yours. I just want to own that we are very cognizant of how much work you are assigning us and that we are asking for full-fledged. We are asking for you to assign us a lot of work that we will have to do over the summer and the fall and then report to you. And also bring back the same groups that have worked on it who will be able to independently judge if we're successful.
All right, where do we leave off?
Section, your third instance of amendment.
What page are we on?
We are on page 7, line 3.
Yeah.
So this instance of amendment in the bill is passed by the Senate. Section 5 is the effective date section. So this instance of amendment would strike the effective date section and we'll add it back in after this. And we're going to replace the effective date language with the following language, which is all session law and it's implementation language. So section 5 is behavioral threat assessment teams implementation. So the first section is subsection A, creation of the model policy. On or before November 1st, 2023, AOE shall issue for public comment a draft model policy and procedures for use of behavioral threat assessment teams required pursuant to, and then that's the language we just walked through. On or before December 15th, 2023, the agency shall issue, publicly post, and communicate to school districts and independent schools the final model policy and procedures. School districts and independent schools currently using behavioral threat assessment teams shall update and implement a policy on the use of behavioral threat assessment teams consistent with the model policy created pursuant to, again, the language we just walked through, not later than the 2024-2025 school year. So if you're already using a behavioral threat assessment team, you have to adopt a policy by that school year. And then subsection B, establishment of behavioral threat assessment teams and training. School districts and independent schools not already using behavioral threat assessment teams shall take all actions necessary to establish a team not later than July 1, 2025. And they have to do including, so these are the things they need to do. Identifying and training team members, which shall include group bias training and the training requirements contained in that training section we walked through.
I'm just going to interrupt for a quick second. And those in the audience can correct if I'm wrong. I think one of the things that had us send folks off to negotiate was a question of whether threat assessment teams may be imposed or shall be. And this is sort of getting to that. And this is really the compromise language that everybody worked out so that it is a shall by July 1st, 2025.
Right. And so these are the things they have to do by then.
So where it says identifying and training team members in the school, right? That's what the school would. So my sense is that all staff should be trained because any staff member could be asked to come in and be a member of the team, depending on the situation. Is that just?
I guess I don't know if this committee wants to get involved in telling schools how they should create their assessment teams.
Okay. And again, I just think would be really good if all staff had some understanding.
And that may very well be happening.
Yeah.
So if you look at E, we'll skip C and D for a second. They do have to provide education to the school community on the purpose and use of behavioral threat assessment teams. So that's very different than requiring each educator to undergo the same training as a behavioral threat assessment team member, but it is a requirement that there be some sort of education about what a behavioral threat assessment team is and does. So subdivision C, line 5, they have to establish procedures for proper, fair, and effective use of behavioral threat assessment teams, and updating and exercising emergency operations plans, and then the community outreach we just talked about. So those are for schools that do not currently have behavioral threat assessment teams, what they have to do to be up and running by the effective date of July 1, 2025. Subdivision 2, for school districts and independent schools currently using behavioral threat assessment teams, they have to certify compliance with the training requirements that we walked through on or before the first day of the 2023-2024 school year. So that's this coming school year. The Agency of Education, Department of Public Safety shall issue guidance and offer training necessary to assist school districts and independent schools with implementation of this subsection. So they'll provide the assistance to get everyone up and running. Subsection C, the Agency of Education shall establish guidelines necessary to collect the data required pursuant to the data collection language we walked through. Each supervisory union, supervisory district, and independent school using behavioral threat assessment teams as of July 1, 2023 shall comply with the data collection requirements beginning next school year. So if they're already doing it, you already have to comply with the data collection requirements. And then page 9, subdivision D is a series of reporting requirements. On or before January 15th, 2024, AOE, in consultation with the Vermont School Safety Center, shall issue a written report on the status of the implementation of the duties and requirements contained in the behavioral threat assessment statute, including the status of the development of the model policy, updates to training and guidance documents, updates on training and professional development requirements for behavioral threat assessment teams, data collected or voluntarily reported to the agency or center, the guidance issued, training developed, and measures implemented to prevent a disproportionate impact of behavioral threat assessments on historically marginalized students, including students with disabilities, to ensure that use of behavioral threat assessments does not increase use of school removals or law enforcement referrals for these populations, as well as plans for future training and guidance, and any grants or funding secured to support the implementation of proper use of behavioral threat assessment teams. And then the following year, on or before January 15th, 2025, AOE, in consultation with the Vermont School Safety Center, shall issue a written report on the status of the implementation of the duties and requirements established to the behavioral threat assessment statute, including the status of data collected from SUs, SDs, and independent schools for the 2023-2024 school year, completion of the development of the model policy, and additional guidance, training, and other measures to prevent disproportionate impacts on historically marginalized students, including students with disabilities, as well as plans for future training and guidance. And then this last piece, I think, is what you all heard testimony on yesterday. On or before January 15th, 2024, the Agency of Education shall submit a written report with any recommended legislative language from the policy stakeholder work undertaken during the creation of the model policy and accompanying guidance and training materials required pursuant to 16 VSA 1485, which again is the Behavioral Threat Assessment Teams statute. So that's all of the actually, I'll just talk about effective dates for a second. So your fourth instance of amendment is adding back in your effective date section. So the effective date section and section 5, the implementation language that we just walked through, those will all take effect on July 1, 2023. Sections 1 and 3 will take effect on July 1, 2023. Section 2 will take effect on July 1, 2024. And section 4, which is the behavioral threat assessment teams statute, will take effect on July 1, 2025. So the statute itself requiring all of those things for behavioral threat assessment teams, the model policy, the adoption of the policy, the training, the everything in that statute, the data collection, that law does not take effect until July 1, 2025. But all of the implementation language we just walked through with its various due dates, deliverable dates, that language will take effect on July 1, 2023. So there's going to be a lot of work that looks like it may not it should not take effect until July 1, 2025, happening because of that implementation language and being required to happen because of that implementation language. Any questions on that?
Or on any others, if we've reached the end. Comments?
Well, it's a question or a comment for the committee, really, which is, you know, there are all these concerns about oversight. There's these concerns about traditionally marginalized populations. I don't know how widely used these threat assessment teams are now, and nor do I know how many times they've come up with something and actually solved a problem or saved a crisis. Maybe there's no way of knowing. But if we have all these concerns, why are we expanding it? Or why aren't we having the same conversation that we have with student resource officers? You know, I know there's a desire to make schools as safe as we can. I know there's a push from the administration to do this, but do we need also to consider not expanding behavior threat assessment teams or not having them at all? Or do we leave that up to AOE and the Vermont law projects?
So I'm not, I don't want to sound like I'm playing advocate for one thing or the other. But I think we have not heard any opposition to threat assessment teams. Everybody in the field has been aware of and been working together on. I'm the first one to sit up and say, this is a terrible bill to have to take up, but we live in a different world than we did previously. So I think that there is support in the field for mandatory threat assessment teams in all school settings.
I thought I at least said some implied pushback from Rachel Seelig and her team, and I assume it's for the usual reasons, but maybe I misperceived.
Yeah, well, I don't think it was against necessarily threat assessment teams in general, but to make sure that if they're going to exist, that they protect all of those issues. And I guess I'll say my general comment on this, and this is not my world or wheelhouse, but what I do like about it is that it right now threat assessment teams exist without enough, I would say, without enough protections in them. And this is adding a much more significant layer of protection for those students who might be unreasonably targeted.
Yes.
Yeah, please, go ahead.
Ted Fisher, Vermont Agency of Education. Apologies for continuing to weigh in. I should say to your question, Representative Neer, we don't have really good data on number of, that AOE really works on school districts and supervisory units, that LA level. Right now, we have good data on that more than 200 schools in Vermont out of the universe of 296 use them in some capacity. We are aware of threats that have been averted. We are aware of instances where they have worked. We don't have great data that's systemic on that.
Right.
We are also aware through our partners, mostly through colleagues like Legal Aid, who have raised concerns for us of instances where the teams are clearly being misused or potentially are being used, even if it's not misused intentionally, they are being used in ways that are very problematic from a student's process perspective or other reasons. Some cases exclusionary. We started this process. This was, if you remember Secretary French's presentations on GQS. We started this process for the whole bill, all 4 sections, wanting to see things that are currently best practice and trying them law so that we could properly regulate them and ensure that school districts use them. That was our goal, was to make sure we use them. We now, as a result of working with our stakeholders, and I would say you heard from Rachel yesterday about she had to go, is that she is in support of this in the interest of seeing it regulated, despite earlier concerns that you heard from her. We now want to ensure from, again, using AOE as a regulatory agency lens, we still believe that they are useful and that they are necessary. I would just completely agree with the chair in his comments. I wish it were otherwise. I really do, personally and also professionally. That said, we want to see them used. We think they're an important part of keeping students safe. We also think it's very important that they've been regulated and that it is, we are not putting the genie back in the bottle. And so not having regulation on it, not having a requirement that allows us to do that oversight is I would say that's potentially very problematic. And and at worst dangerous.
Thank you, that's very useful to me.
I'm going to just pause for one quick second to talk logistics. I have a meeting with the speaker at 2. The conversation is going to continue. Aaron will run the meeting. No vote will happen until, we'll put the vote off until 2:45 before we go to the floor.
Can I just ask,
I'll be back. I'll be back by 2:20, I'm sure. Yes.
can I ask a question? I'm going to add that language that you wanted regarding age appropriate, but I'll need to get it to editing, and I was just booked somewhere else at 2:15. So I will do my best to get that to you before 2:45.
Okay.
I can't guarantee it.
Good. I'm not sure we need to have you here for the vote.
I don't, but I'm literally getting the language to you by 2:45, even over the interweb. I'm not sure I'll be able to do that.
That's not, for those small changes, we don't necessarily need to have.
We do. If you're going to vote on something, it needs to be fully edited.
Okay, all right. So as soon as we get a clean copy, we'll have a vote. I'm going to leave. I'll be back in 20 minutes, but the conversation may continue, although until Beth has to go, and then we need to switch topics anyway.
Representative Williams. Took me a minute. I wanted to say Terry, but formal.
Yes, question, Beth. So I did a search, Senate version of the words behavioral assessment. And I came up with 6 different times where it came up in the document. And the new version, the House version that we're doing, it came up 26 times. So is that because their version is a should and our version is a shall? And because it's a shall, there's a lot more detail that has to be included?
I don't know that I would make that specific connection. The language passed by the Senate is a should, is a may.
May.
And it just does not require as much, and it's just a much shorter section. So the language you have in front of you is a shall and does have several more requirements, and it adds the implementation section. And so there's just a lot more language. But I don't know that I would say it specifically because it's a may versus a shall. There just happens to be a lot more words in the second, a lot more concepts in the amendment, in the language proposal before you.
So question? Yep. Representative Austin.
Thank you. I'm wondering if it would be possible for our committee and maybe the Senate committee to get, once the policy language is drafted, if we could also get a copy of that report.
Yes.
Because I didn't see it, but maybe it's in here, but I didn't.
Yes. So if you look at page 9, the first reporting requirement is next January, and it requires status on the development of the model policy. And then the second reporting requirement is January of 2025. And it also includes completion of an update on the completion of the model policy. So there is language in there requiring updates on those things, but it doesn't specifically say the model policy shall be provided to the General Assembly.
Could we put that in? Should these two? Maybe not the model.
Ted Fisher, Agency of Education. I don't want to contradict that because I could not do her job. And she's right. We will in the report include the model policy language for you.
Okay.
And I would be absolutely happy to also send it to the committees.
Great.
Even when it's issued, which will be earlier than the report due date.
Great, thank you.
And it will also be posted publicly for public comment, as well as we're in the process of having initial pre-passage conversations about what the stakeholder engagement process will look like, as well as the final policy will be posted prominently in our website as practice.
Thank you.
Does this have to go to another committee afterwards?
a good question. Let's see, is this going to judiciary?
Curiosity question.
No, probably not. And we have no money in it,
Right.
right? No, I think it will go back to the Senate because we've changed. I mean, we need to get it out in order for it to go back to the Senate because we've made some changes to their bill. Am I missing anything?
No, it doesn't appear that there's anything in here that would send it to a money committee.
Right.
I am not the one to decide whether this goes to judiciary.
No, yeah. I don't think that's the intention for it in terms of its path right now.
So we get a text message. Okay.
Other questions on the language in front of us? Ted? Sorry, did you?
I was hoping to make a brief comment, but I don't want to do so until members have a chance to ask questions.
Other questions on it? Again, we're not voting yet because we need to get the clean language and have our chair here, so we're not quite there. Other questions about it? All right, you're on.
Again, Ted Fisher, Agency of Education. I just want to say on behalf of many people who have worked on this from multiple state government agencies, as well as our partners in the field and some of our other stakeholder partners. We really appreciate you taking this up. We would not be doing this, to the chair's comments earlier. We would not be doing this if we didn't feel that we had to. It's not something that we would want to be here doing. We've had many conversations as part of this, and I really have personally enjoyed the process, and it's been really fruitful to getting something that will be really good. We're already in the process of talking about what comes next because we have a lot of work to do. So assuming that you decide to support this and that your colleagues on the Senate agree. And a lot of those will be focused around making sure that the appropriate groups who have interest in seeing students protected are at the table and have those conversations. And so I just want to thank you for considering this, understanding it's very late in the game, and understanding that this is not the most. We wish we were in different circumstances, but we certainly, our interest is again making sure that students are safe, that there is not, that we can as early as possible identify potential threats and ensure that they do not happen. And then we can also, while we're doing it, ensure that the rights of students are safeguarded and make sure that students, historically marginalized students, students of color, students with disabilities are not disproportionately impacted by the policies. So again, with that, we see two real important reasons to recommend this question earlier to get this done. So I just want to thank you all for hearing us out, for your consideration.
Other thoughts? I'm going to take liberty and add my own comment. I appreciate all the hard work on this bill. I appreciate, we have got some great expertise or some supportive good expertise in the state. I reached out to Rob Evans in the School Safety Center just right after Uvalde last year and thinking about kind of, work that needs to happen. Obviously not anything anybody in school wants to be doing or using our resources on. I will just hope, as we are in the waning days of this session, we've also passed really strong legislation to secure safe storage of firearms. And 75% of school shooters got their firearm at home that was not secured. And so that is not this bill, but that is also this session, and that is also school safety. And so I hope that there's some more support for that work in trying to better protect our students and reduce violence. And with that, we will shift, because we will be coming back to this.
Thank you.
I'm working on an amendment and I will.
Thank you.
Like all that.
Okay. All right, we are shifting back to S103. Obviously, I've been keeping a tally. We have a lot of questions for different entities to answer. At this challenge, we have the opportunity to hear from the school boards, and we still, how much longer do we have, you, Beth, when we start?
Oh boy, 2:30?
Okay, all right. So as we continue to consider oh no, sorry, I'm looking at the wrong thing. You're not under 103. Never mind. You're fine. Never mind. I was looking under 138. There's a 1 and a 3 and okay, sorry. 103, we just have Sue for answering some more questions and continuing our discussion and thinking around S103 and what we can do substantially to improve school climate and reduce harassment, hazing, and bullying. Do you have testimony or just want to answer questions at this point?
I do have testimony, and I submitted it in writing, it's on your website.
Multitasking way too many things, so thank you.
So good afternoon. My name is Sue Siglowski. I'm the Executive Director for the Vermont School Boards Association. I've been asked to provide some input on S103 and information about the school board's role in addressing harassment. Excuse me. The version of the bill under consideration includes changes to the definition of harassment in 16 VSA section 11 subsection 26 and the standard of liability in 16 VSA section 570F subsection C. S103 as passed by the Senate, as you know, did not include these changes to education law. The changes to the definition of harassment and the standard of liability that are proposed are significant changes that should be given due thought and consideration along with input from involved stakeholders. These proposed changes are coming into play during the last days of the legislative session without time for that type of process. A proposal for significant change to the law should start with an understanding of current law and how it's working. In its final discussions on S103, the House General and Housing Committee discussion was not based on facts about current hazing, harassment, and bullying law in Title 16, as evidenced by statements that the AOE model policy is optional, not mandated. And as you've heard, it is a required a required policy. I've included in my written testimony a memorandum that VSBA filed with the House General and Housing Committee correcting the record, and we are certainly thankful to the House Education Committee for taking a more deliberate and informed approach. As I begin this testimony, I want to convey that the VSBA takes a strong stand against harassment. We're committed to ensuring that every student is in a safe, secure, and welcoming learning environment. And we're committed to equity, which means each student receives the resources and educational opportunities that they need to learn and thrive. One of the ways we have shown our commitment is by fully supporting the changes to the education quality standards put forward by the Act One Working Group. Those proposed changes, which are now under consideration at the State Board of Education, add to existing non-discrimination protections, and they also require schools to be anti-racist, culturally responsive, anti-discriminatory, and inclusive learning environments. Additionally, they require schools to foster a classroom culture based on the tenets of restorative justice practices, which are relationships, respect, responsibility, repair, and reintegration. The proposed EQS changes further require schools to impart a comprehensive historical and socially conscious understanding of the causes and effects of bias and discrimination, why all persons should have equitable access to social and economic opportunity, why persons and institutions must identify and prevent individual, group, and systemic racism, discrimination, and all forms of unfair treatment, and the positive and multifaceted contributions of different social, cultural, racial, linguistic, ethnic, and indigenous groups to the historical and ongoing project of building and strengthening democracy in the United States and globally. In addition to supporting the changes to the EQS, we're committed to gaining a full understanding of the new federal Title IX regulations to be issued, we think, later this month. Among other changes, we expect the rules to include protections for transgender and non-binary students and expand the definition of sexual harassment, decreasing the threshold for when schools are required to begin an investigation. The upcoming changes in the federal regulations under Title IX will require changes to the Vermont Agency of Education's model policy and procedures on hazing, harassment, and bullying. S103 would make major changes to Vermont education law before the impact is known of changes to the federal Title IX regulations regarding sex-based harassment, and before related procedures for prevention of HHB are updated in the coming months. These changes likely will have significant impacts on the concepts addressed by S103 and should be fully understood before revisions are proposed to state law by S103. Additionally, we are aware that S103 could create significant additional liability for school districts under the First Amendment. We certainly hope that this committee and all committees taking up this topic will pursue additional information to understand that issue more fully before moving forward. Next, I'll move on to the duties of school boards to prevent harassment. As you know, current law 16 VSA section 570 subsection B requires every school board to develop, adopt, and ensure enforcement of and make available an HHB prevention policy. I wanted to let you know, in case you haven't heard about it already, that the Vermont School Boards Insurance Trust has a school board toolkit that provides a review of the prevention duties and responsibilities of school boards in this area. And I've included a link to the toolkit in my written testimony. The duties and responsibilities that are listed in that toolkit, there are 9 of them, and I've listed them in my written testimony. They're the duty to adopt the policies and procedures, ensure publication, ensure distribution and notification to students and parents and guardians, ensure distribution and notification to school district staff, teachers and employees, ensure training of school district employees regarding duties and responsibilities that are imposed by those policies and procedures, educate students on hazing, harassment, and bullying and the policies and procedures content, assign 2 or more employees as designated employees, designate an equity coordinator and a Title IX coordinator, and lastly, conduct board hearings to consider respondent appeals of policy violation determinations and related discipline matters. For each of the 9 duties listed above, the school board toolkit provides specific information on steps boards should take to comply with those duties. And then additionally, the toolkit provides a guidance memo on school board appeal hearings, which answers 13 frequently asked questions. So if you have any questions about the school board appeal hearing, they're probably answered in that guidance memo. It's quite comprehensive. There's also a form for acknowledging receipt of a board hearing request. There are separate templates for conducting a board appeal hearing in the case of bullying, harassment, sexual harassment, and hazing. I believe there's 4 separate templates in there. And there are forms for announcing the board's decision following the hearing. So that toolkit is quite comprehensive. I believe it's about 45 pages long. VSBIT also provides HHB toolkits for superintendents, employees, building administrators, designated employees, and investigators. So separate toolkits for all of those entities. I also wanted to note that the Agency of Education publishes the list of public school designated employees. So remember I said there need to be 2 designated employees. Those people are listed online, and I provided a link to that in my written testimony. And I wanted to note that the Agency of Education's website states that a list of private school designated employees for the 2022-2023 school year will be available soon. But that school year's almost over. Thank you for the opportunity to testify on S103. As I said in the beginning of my testimony, the SBA is committed to addressing harassment in schools. We're also committed to working proactively to help school boards create strong and healthy school cultures that prevent incidents of harassment, hazing, and bullying from happening at all. And just lastly, I included a few ideas for future consideration. One idea is to require training on hazing, harassment, and bullying prevention in the annual training that's mandated for superintendents and board chairs to do together. They're supposed to do 8 hours, they're required to do 8 hours of training annually together. And I've included in my written testimony the topics that are required to be covered, but HHB is not one of them. So you certainly could add that to the list. It might need to increase the number of hours because there's quite some weighty topics on that list. Another thought is the possibility of requiring school boards to adopt a policy addressing educational equity. And I would note that the SBA does have a recommended model policy available to its members already on that topic, but it's not required by law. And lastly, just wanted to echo the testimony of other witnesses that you've heard about the importance of human and financial resources to ensure implementation of the updated model HHB policy and procedures. Thank you very much and happy to answer any questions.
Yes, I was wondering if I could get some clarification. I've heard in the bill that HHB and Title IX are very different, that Title IX is like a mini court proceeding and very complex, and schools have challenges doing them, and I would just like to hear your response to that.
I think it is challenging because, school employees, I don't think many or many of them have been to law school. It's a really complex process, and it requires a significant amount of training for them to understand how to do it properly. And they are, you've got the federal law and the state laws, and investigations required for multiple types of behavior. So it's definitely a complex area.
Representative Minier.
Technically, I have two. I'll start with one and then see if anybody else wants to go. The first one, I tried to click on the link to the memorandum that you filed with General and Housing, and it took me to a dead page. I was wondering if there's any value in characterizing it, or if we should just wait and see the actual memo later.
Oh, yeah, I could. That's interesting that it didn't.
That page not found. Yeah.
Yeah, so I can pull it up right now on my computer. And I'll send a corrected document. Hopefully it's still on their website. I looked earlier today and it was. So the memo I submitted was an official request to correct the April 27th record of the House General and Housing Committee regarding committee discussions. And I provided information that during the morning discussion at 27:42, which is the point on the video, a committee member stated that the Agency of Education's model policy on prevention of HHB is optional and not mandated. The committee member also stated that there are many school boards in the state that do not have the willingness to adopt an HHB prevention policy. And then the same committee member repeated that assertion during the afternoon discussion at 53:43. And I provided links so you can listen to it. And unfortunately, Legislative Counsel with knowledge of education laws was not present to correct that misinformation.
Thank you.
You're welcome.
And Brady, shall I go a second time or be quiet?
Go for it.
Okay. And then the other question, you alluded to it in your testimony, and we all know it. There's been a lot of information coming quickly at us. I think I understand that the correct standard from court precedent is severe or pervasive, but there was some question about what standard is currently used for harassment in schools. Is it required currently to be proven to be either severe or pervasive to count as harassment?
I believe Heather Lynn answered that question yesterday or provided that information yesterday. I think she said that it wasn't.
I'll see if I got to know it. Yeah, it's been tough for me, that one. Yeah.
I can find more information on where that was yesterday.
Representative Boston.
Thank you. It's very compelling testimony. Thank you. I have two questions. One is, and it might have been in the bill, but is there any way that the victim cannot be is protected from their identity is protected from the perpetrator, the alleged perpetrator? Or does an alleged perpetrator always have the right to know who's making the accusation against them?
I would need to look into that question. I know that there are a lot of privacy rights of students, but I don't know the answer to your question.
And just maybe I have three things, but my experience is that where this occurs is where there are not teachers, and like recess the bus, online, in the cafeteria. I don't remember ever having something happen in the classroom, because I think teachers are really good at addressing it, at least they were. And I just don't know if you have any thoughts of how to address it.
Well, as I spoke of earlier in my testimony, we really support the changes that are proposed for the education quality standard. And I think if those changes are implemented well, which is going to be a big lift, but it's going to be critical. If they're implemented well, I think that they will help to improve the culture of schools. And if that happens, the hope is that the type of incidents that you're referencing won't happen.
And just the last question, like school boards, do you have a rough estimate across the state of how many of these instances have risen to the level where the school board is hearing them, have been brought to the school board level?
I don't have that data.
Okay, thank you.
That's my question exactly. Representative Boston.
Thank you. I've been hearing a lot about the totality of circumstances, which doesn't seem to exist, which kind of right now it could be bullied by 12 different kids for the same thing, but because it's just the first instance, it can keep kind of going. So I wanted to know if you had, I have three questions, but that would be my first one is, what's the school board's position on totality of circumstances?
I believe that at least the proposed Title IX regulations have some new language regarding totality of circumstances.
And I noticed in the number of designated employees just now in my district, they're all principals. There's typically only one in the school. Is that typical of, I was talking to another school board member who said they have multiple designated employees because one, it's important to make sure that it's not just the principal. Mm-hmm. The principal can sometimes tend to suppress a situation, which actually happened in my school. So I'm just, is there any thoughts about increasing the number of designated employees in each school system to help HHB?
Currently, there's a duty to assign 2 or more.
Okay. So this sheet may not show like every single person. It might just show the point person.
That's what I'm guessing out of it, because I know in our district that there's more than 2.
Oh, so it's right, it's district-wide. So there might be only one person at each school, but somebody from the district could step in to a different school.
Our school, I believe, our district breaks it down by school.
Okay.
So each individual school has 2. They actually have more than 2, but there's only 2 listed on.
All right.
But the staff knows who the designated people are and can go to any of them.
Okay.
That's my district. I don't know how it looks everywhere else.
Yeah, on this list, we only show one at each elementary school. Okay, And my last question was, we heard earlier from the AOE attorney that they don't have the authority to ensure that these policies are being implemented. What does the school board do in terms of trying to make sure that each school's utilizing the, implementing the policies and procedures?
The way a school board would ensure that is, of any policy that they have, is to ask for a monitoring report from the superintendent.
And does that happen frequently, or is that just happens when there's something that goes awry? Or is that an annual typical thing?
School boards will do that annually. I cannot really speak to whether they do it annually for their HHB policy.
Okay.
But they do annually ask superintendents to report on various policies.
All right, I got to go again. In the meantime, just to confirm Sue Siglowski's memory, it is true both that Heather Lynn testified that Vermont law does not require harassment to be pervasive or severe. And the only time that's referred to in the hazing, harassment, and bullying policy is to say that a hostile environment exists where the harassing conduct is severe, persistent, or pervasive. But harassment means an incident or incidents, so it's only one that's required, both in Vermont law and in the HHB policy.
Thank you. Other questions, Representative Stone?
No, I'm looking at the VISBIT HHB and Title IX toolbox, and I just wanted to go back to what you were saying. It says per school campus. To assign 2 or more employees as designated employees per school campus. Take it as you will, but that's what's written.
As we look towards our deep dive into HHB, and the same concept keeps coming up in this committee often, which is about enforcement. What is your recommendation? Who's the best? Is it AOE to do enforcement? Is it individual school boards to do enforcement? It just feels as if we've got some schools knocking it out of the park and doing a really great job with their school culture and others not. And I just want to get your opinion on enforcement and which entity would be most equipped or best equipped.
Well, I think initially each school board should be monitoring this policy and asking for a report at least annually. And if there are persistent problems with a particular system, then certainly there is the possibility of asking the Agency of Education to take a more active role. Right now there's rulemaking happening that involves the district quality standards and quality assurance. So there may be some room in that quality assurance process for this type of issue.
And do you find that, boards change constantly, and that's a huge issue just in terms of if there's something that's an annual thing that the board is supposed to do, it's kind of how well does the handoff happen from one, school board president to another? Is there a system set up to aid that transition to make sure that things don't fall through the cracks?
I think each local district has their own approach to that. I don't know that they all have a good system that they use, but I do know that I get a lot of questions about orienting new board members. That's a big concern for boards, making sure that new board members are aware of their responsibilities. And having been a school board member myself, I can tell you, I think it took me a couple of years to really get fully in what I consider to be fully informed to be a effective school board member. We do provide a lot of trainings for school board members. We provide monthly webinars. This month, we have a new school board member training that is designed specifically for newly elected or appointed school board members. Also this month, we're providing the joint training that I spoke about for the superintendent and board chair. So we do try to provide them with as much information as we can.
Is there like a checklist of all the annual things that they should be looking at or making sure that they can report from the school?
There isn't a checklist, but that's a good idea. You might want to develop that. Thank you for that. We do have on our website toolkits for them, and that, like, there's a new board member toolkit, there's an essential work of school boards toolkit. So there's quite a bit of information about on our website as well.
Other questions? As far as you are aware, are we the only, we would be the first state to make this change in terms of student behavior and in schools, not in a labor context? Is that
Yes, that's that, as far as I know, that's correct. I think the examples that have been given are all to the different committees are all in the employment context.
Other questions? Yeah, Representative Austin.
I am curious about the role of parents and their responsibility, you know, to working with the school or learning with the school, you know, if a student is accused or found to be harassing. I mean, can you talk at least to I think most parents would be supportive of the school and follow up with the recommendations. Is that what you're?
That would be the hope. What I've heard anecdotally is that, especially in the last few years, more parents are challenging those findings.
Yeah, I believe that without a alignment with the parents, it will be difficult. It's difficult. It's much more difficult.
All right, any other final questions? Yep, Representative Voss.
So social media training has come up in our conversations, and what does the School Boards Association, is there a recommended training on how to deal with social media in schools? And
We do not have a training related to that. You know, we sometimes get questions about what's appropriate for a school board member to do on social media. And I think we've had a webinar about that. There's a lot of questions when it comes to social media.
Call. Okay. Oh, Representative Stone.
Yeah, sorry. What would your thoughts be on offering trainings to schools on how to do investigations? I know there's been some pushback with people feeling that investigators may have biases because a lot of them are former administrators, et cetera. How would you answer to those concerns as far as how we're training investigators in our school? Do you feel like there's a way we can do it better? And if so, what would that look like?
I don't specifically have any recommendations for ways to do it better, but I would note that there is the ability to ask for an internal review, and then there's also the ability to ask for an independent review, which would be someone outside of the system. So I think that is a good measure to have in place, and that is in place currently. I wanted to go back to your question, Representative Fuss, because there is a model policy. Just trying to find it. It's required. And it has to do with electronic communications. So here it is, electronic communications between employees and students. That is in our model policy manual, and that's already required by law. It sort of relates to your social media question, I think.
while I'm on
Go ahead.
the idea train over here. What would your thoughts be on a student bill of rights? I'm just thinking about some of the things you've raised about parents' involvement and just like, I feel like a lot of what we're experiencing right now in this room comes from a lack of transparency of people knowing what already exists. So I'm trying to figure out like how to improve that. What would your thoughts be on something like a student bill of rights, just to improve transparency for students and their parents?
That's an interesting question. We don't have a position on a student bill of rights. I will note that it was a couple of years ago, there was some work done to develop a shorter explanation of the HHB process for parents. And I'm not sure if that was fully disseminated. I want to look into that because I think that would be really helpful.
Yeah.
I think we'd be interested if you find out anything more about that.
Okay.
Helpful follow-up.
Okay.
For us. Yep. All right. Okay, we will pause there on 103. We will take a 3-minute break. Find the chair. And then hopefully be moving towards a vote on 138, but we might as well use the opportunity. People need a couple minutes to stretch, take a quick break.
Yep, back here at 4:12.
Yeah, let's say 2:45. Yep, he's not here. What the heck? 2:45.
You can count.
Great.